are you? And where are you going? What do you want?
Hello and welcome to Trust and Estates Weekly. I'm your host, Kevin Bemmel, and I'm here every Monday at 10 a.m. Pacific Time to talk about estate planning and trust and estate administration to help professionals like myself better serve their clients, but also for you, if you have trust and estate issues that you're working on, you can speak more intelligently to your advisors and to your family members, etc. So unfortunately, my guest for today couldn't make it. And so I'm going to be doing a change up here. And I'm going to be talking about the liability that an executor or a professional fiduciary like myself has when he administrates a probate, or really for that matter, a trust. The trustee under a trust has typically much broader authority, and it's much harder for the beneficiaries to challenge the trustee's actions. But in any event, when someone is administrating a probate or a trust, that person sits in a fiduciary capacity. And so what does it mean to exercise that authority? What are the duties, and what are some of the problems that arise, and how can they be dealt with and preferably avoided? So first of all, I'm going to talk about the fiduciary duties that an executor or an administrator or a personal representative, all of those names apply. You may have heard the term executrix. That's a woman who handles the duties of an executor. You don't hear that too often now. I think I'm one of the few people who use that term anymore. And the duties really come down to four, and these all fall within the categories of performing one's fiduciary duties. So first of all, there's the duty of loyalty, and this is really at the heart of one's fiduciary duties, and that is, as I'm going to use the term personal representative because that is all encompassing of whether it's an executor, executrix, administrator, etc. So as the personal representative, or the PR, they must act solely in the best interest of the estate and the beneficiaries. That is their job. Okay. And so every decision made needs to be processed through that filter. Okay, so what that means is there can't be any self-dealing, there can't be any special special treatment offered to, for example, someone who's the partner of a property with with the estate. That unless something the personal representative does is in the best interest of the estate, that is most likely a breach of fiduciary duty. Okay, so the main the sort of the main issue is the PR cannot use estate assets for personal gain. Okay, and we'll talk about kind of how that could happen, what those breaches are in a few minutes. So that's number one. Number two, the personal representative has a duty of care. So he must manage the estate prudently, i.e., he has to timely collect assets, whether it's monies, whether it's gathering in the actual assets, real estate, personal property. All of that needs to be done in a timely way. Now, it's an interesting factor in in estate administration that these things tend to take a long time. Okay, now in my experience, that's usually not because the executor or the personal representative isn't trying to move things along, it usually has to do with other factors like how busy the courts are, or uncooperative heirs and beneficiaries. They slow the process down. Okay, so and again, when we talk about preventative practices, you'll see some of the ways that a personal representative can deal with that. So he can show that any delays were not caused by his actions. So the duty of care, timeliness is among them, making sure bills are paid, investments are properly managed. All of the myriad details of duties all have to be done carefully, and prudently would be is really the best word. Okay. The next is the duty to act impartially. So if there are multiple beneficiaries, okay, they need to be treated impartially, fairly, regardless of whatever personal relationships may exist between the personal representative and any particular heir. And indeed, one heir may be only getting a small portion of the estate and another heir may be getting a lot more. That is not a basis for uh, unequal treatment of the heirs, except in the matter of distributing their respective inheritances. Okay, so if someone is a 10% heir, they have just as much right to communication with the personal representative as someone who's getting perhaps the other 90%. Okay, so there's a duty to act impartially and it should be scrupulously maintained. And then finally, there's a duty to account. So it's all good and well if the personal representative acts with loyalty, care, and impartiality, but their word is typically not sufficient to to rebut a complaint that they haven't fulfilled those duties. And so there's a duty to account. There's a duty to keep accurate records, especially of all financial activities and decisions, and to provide clear reports to the courts and the beneficiaries. Okay. And while the stress is going to be on financial issues, there are many things that a personal representative handles that may not be solely financial, and nonetheless, there should be careful records kept of those matters. All right, so those are the basic fiduciary duties of a personal representative. So, what are some of the common areas then where those duties are breached? Well, one of them is what's called commingling. Commingling happens when a fiduciary mixes his personal funds or the funds of his business, that they amount to the same thing, with, for example, the funds of the estate. And so, anytime a personal representative is acting, there should be a separate account for the estate, and that account should carry the estate's federal tax ID number, federal FEIN number, federal employment ID number. Okay, and it's particularly the personal representative should be particularly careful to make sure not only is the account separate, but it has a separate FEIN in order to ensure that no commingling or no appearance of commingling is taking place. Okay, so you know, if you're owed a fee, for example, okay, let's say the estate's account is getting a higher interest rate on its funds than you get on your own. And so, maybe it's a much larger amount of money. And so if you leave your fee there, okay, you'll be getting more money. Well, you can't do that. Okay. If you were to take the interest that your fee earned while being in the estate's account, that could even be something worse called conversion. It could be considered stealing. Okay, so make sure, going back to the duty of care, that you're timely. You're not, leaving your funds sitting in the estate's account once they're due to you, and trying to, benefit by that. Okay, so don't commingle, don't convert funds. Conversion of funds is the actual taking of funds by the personal representative when they do not belong to him. Okay, and conversion is a fancy word for stealing, as I alluded to a moment ago. Okay, so be scrupulous in the handling of money. Okay, those are sort of the legion breaches by personal representatives. Okay, delaying distribution of assets or liquidation of assets without justification. Okay, so if a property needs to be sold in order to perhaps pay estate taxes, for example, or in order to meet other obligations. Okay, let's say there's a creditor to the estate who's entitled to a large sum of money. The unjustified delay of selling an asset may be in order to earn additional interest for the estate. That could be a breach of one's fiduciary obligation. Now, I mentioned a few minutes ago, the estate must act solely in the interest of the estate and the beneficiaries. But remember, a creditor to the estate has a claim on that estate, and that claim is superior to the beneficiary's claim. So if that creditor is not paid timely, that creditor could petition the court for interest on its claim, for a quicker sale of the asset. And in any event, if a dispute arises because of the creditor not being paid, that could mean additional costs to the estate. Okay, all of that is not in the best interest of the estate. Okay, so delaying distribution or distribution of or a liquidation of assets without justification, that's another type of breach. Now, there may be a justification. Okay, and so in that case, that justification should be documented. So if there were ever a question, it can be shown. The records can be shown, and the case made that this was justified, and here's why. Okay, and then the next one is something I just mentioned: failing to pay debts or taxes on time. Okay, so the failure to pay a debt or taxes on time could result in the estate having to pay penalties, and if that's the case, that means the funds left for distribution to the heirs have been reduced, and that could be considered a breach of a fiduciary duty. Okay, and then ignoring provisions in the will or ignoring court orders, again, pretty obvious breach of duty. Now, there could be a court order that, as the personal representative, you intend to dispute. Okay, so the court can issue an order. That doesn't mean you have to immediately follow it if you think the order is not in the best interest of the estate. So then it may be perfectly justified to take time to consult with your lawyer and to discuss on what basis the order could be challenged or overturned. Okay, so when we say ignoring the provision of a will or a court order, again, that's without justification. There may even be justification for ignoring a provision in the will, and or ignoring what appears to be a will altogether if there's concern over the validity of the will or over validity of the provision. Okay, so in that case, again, you want to consult with your lawyer, but you don't want to unreasonably delay looking into those if you think there are grounds for not complying with a court order and not complying with the provision in a will. Okay, so what could be the consequences then of a breach of one's fiduciary duty? Okay, so first of all, there could be personal financial liability for losses or mismanagement. So, if if the breach is particularly egregious, so then it's possible that the personal representative will be held personally liable. Okay. Now, that may happen through negotiation with the beneficiaries. Uh, they may be represented by their own legal counsel, and that legal counsel may contact the personal representative's lawyer, and they may negotiate some kind of settlement based on some kind of breach of fiduciary duty without the court getting involved. Okay, but the beneficiaries also might take legal action against the personal representative, and in that case, uh, now the court is going to get involved. By the way, creditors, as I mentioned, they too can take legal action against the personal representative if they think that there's been a breach of his duty. And so now the court will get involved. There could be hearings. There may still be a negotiated settlement, and then perhaps a stipulation to the court to settle the matter. Okay, but that's another consequence of a potential breach of fiduciary duty. And finally, the personal representative could be removed as the administrator for the estate, or the trustee could be removed as the trustee for the trust. Okay, which typically will result in some reputational harm. All right, so the penalties can be quite big for breaching one's fiduciary duty, and having that breach sustained especially in a probate court. When life brings unexpected changes, managing inherited property shouldn't add to your stress. Magnum Properties specializes in probate and trust real estate management. We handle the complexities while you focus on what matters most. From property maintenance to tenant relations, from legal compliance to maximizing value, we're your trusted partner through every step. Magnum Properties, Inc., turning property challenges into peace of mind. Call us today at 213-264-4396 or visit magnumprops.com. Okay, so this is Trust and Estates Weekly, and I'm your host, Kevin Bemmel. We're talking about the duties of a personal representative, and the types of breaches that might occur, and what would happen as a result of those breaches. So I've already talked about what is the fiduciary duty, what are some common breaches and their consequences. So what can be done from a preventative standpoint to better ensure that a breach won't happen or won't be alleged? Okay, and the first thing is to maintain open communication with the parties that are involved. So I know in my practice, I send out a weekly email update about the administration of an estate to the interested parties. It could be to the beneficiaries or heirs, could be to creditors. It's typically will go to the lawyers involved. Okay, and that way they know what's going on. So first of all, they cannot sustain the allegation that they're not being kept informed. They are. Number two, they know the specifics of what I'm doing, so that if they don't like something, or they think something is wrong, they have an opportunity to respond about that in a timely fashion. Okay, so let's say that I were handling an estate, and for some reason I appeared to be, delaying the sale of an asset. Okay, so that will be reported along with the justification for it, so that if someone who has an interest in seeing that asset sold quickly, if they think I should be proceeding with a sale, they have an opportunity to respond. Now let's say 2 months goes by, and then they say, well, you should have sold it 2 months ago. Well, so then the response to that is, you knew about it 2 months ago. If you thought I should have sold it then, you should have said something. You didn't. So you can claim that I've breached my fiduciary duty, but now you're talking about hindsight, and most likely, well, not most likely, but hopefully the court will see that and say, this is an act in bad faith, and Kevin has fulfilled his fiduciary duty. Okay, so keep open lines of communication, provide regular updates to the interested parties. Okay, that's number one. Number two, as a personal representative, you should make sure that you have professional assistance. So the typical executor or administrator, even the typical professional fiduciary, is not a lawyer, and they are not experts in probate law. They're experts in, well, if they're a professional fiduciary, they're experts in probate administration. An executor or sort of lay administrator, they may not even be experts in administration. They may just have been the person that the decedent appointed. And so having legal advice on a regular basis is very important. So is having accounting advice. Again, most personal representatives, they're not accountants, and even if they are, they may not have knowledge about the specifics of accounting for probates and for estates and trusts. And so an accountant who has knowledge and experience in that area should be brought in for their assistance, and that would be a valid expense for the to the estate for the personal representative to get that advice. And then financial advisors may be needed, real estate advisors may be needed, appraisers, business appraisers, business people who specialize in business transition. There could be a whole range of professional assistance that a personal representative engages, depending on what are the assets in the estate, what are the issues the estate faces, etc. Okay, so the main thing is, don't make decisions by guessing. Okay, get the proper advice, get legal, accounting, investment advice, whatever issue it is with which you're dealing. Make sure you get the proper advice. I'll give you a somewhat ridiculous example. So here in the city of Los Angeles, when a well, I don't know if it's just a residential property or any property is sold, there's a form that has to be completed and submitted to the building department. And recently, that form contained a provision where the seller must certify as to whether there are protected trees on the property. Now, between you and me, I have no idea what a protected tree is. Okay. And so on one of the estates that I'm handling, where a home is being sold, we're in escrow, and up pops this form. And unlike other parts of the form where the buyer can waive having a disclosure made about certain aspects of the property, the buyer cannot waive having the seller declare or certify, I believe it's under penalty of perjury, as to whether there are protected trees on the site. And so the escrow officer sent me this form to sign, and I got back to her. I said, I can't sign this form. I have no idea whether there are protected trees on the property. I don't even know what one is. And so we had to spend time. I mean, the escrow officer did this. This shows you the quality of this particular escrow officer. By the way, her name is Charity Score. I'll give her a plug here. Gosh, what is the name of her escrow company? I don't remember, but she's with an escrow company in Beverly Hills. So she found an arborist who can go on site and survey the trees and give me a report as to whether there are protected trees on site. Very inexpensive, like $99. Okay, so it would be a breach of my fiduciary duty to sign that form certifying either there was or there wasn't, without knowing whether there are or are not protected trees on that site. Okay, so the $99 expense of the arborist survey is a justifiable expense in this case to make sure that I'm getting proper advice and not creating a liability to the estate. Okay, so If you don't know, get professional advice. And if you're not sure who should be giving you that advice, reach out to your lawyer, your accountant, whomever. Reach out to another fiduciary who's more experienced than you are, and they will help you. Okay. Uh, Next, another preventative practice is meticulous documentation. So keep receipts, records of transactions, statements, even a timeline of decisions can be beneficial if it's something that's going to take a long time and might potentially be controversial. Okay, so keep good records. If you have to account for money, I would recommend using some kind of accounting or bookkeeping software so that you can generate reports easily, and or hire a bookkeeping service. So my friend, I'm giving lots of free plugs here. So my friend Vaughn Marie in New York, she has a bookkeeping and accounting service, and she specializes in trust and estate matters. Okay, so bring in someone like Vaughn Marie, and she will be happy to help you. And again, while there's an expense there, if there's a lot of money being handled, and having accurate books of account is going to be potentially difficult to maintain, you want to bring in a professional to do that. Okay, and then finally, if you're in doubt about something as a personal representative, you can apply to the court for guidance. Okay, I'll talk about this a little bit more in a few minutes, but just because you're not required to submit something to the court for approval, that doesn't mean you're prevented from doing so if, in your opinion, or your lawyer's opinion, or your joint opinion, it makes sense to get the court's approval in order to ensure that you're not breaching your fiduciary duty and creating some kind of liability that you would want to avoid. Okay, so again, I'll talk more about what that is in a few minutes, but again, just to be clear, even though you may not need to get approval by the court, that does not prevent you from seeking it. And it may be prudent to do so in many circumstances. Okay, again, especially if you're dealing with a contentious administration where the beneficiaries or heirs are in dispute, and perhaps one of the more of the beneficiaries doesn't like that you've been appointed the personal representative. So then the court is there to ensure that whatever steps you're taking in the eyes of the court before you take them are a fulfillment of your duty, and therefore you're protected from some kind of adverse action on the part of the beneficiaries or creditors or whatever. Okay, so what then are the remedies that a beneficiary, or really another party, could use if they think that the personal representative has breached his fiduciary duty? So I mentioned these a little bit a few minutes ago, but first of all, if there's an informal dispute, so the beneficiary, or if they're represented by legal counsel, their lawyer could request records or raise concerns directly with the fiduciary. That's always the best way to start. So if you think there's been a problem, that doesn't mean there is one. It's prudent to do some kind of investigation. So if you're a beneficiary, or you're representing a beneficiary, or maybe you're representing a creditor, so the prudent thing to do is to check it out first. Now, if the personal representative is being uncooperative, so you may not be able to do a whole lot of investigation, and so you may need to go on to the next step without having done so. And then once the legal process is started, now you will have tools at your disposal in order to compel the release of information. Okay, but always best to start things off, without creating more of a dispute. Okay, more potential bad feelings, and just raise the concerns. Hey, you know, this doesn't seem right to me. May I get the records related to this so I can review them and satisfy myself that indeed, what you did is proper. Now, if the fiduciary is wise and is a good fiduciary, a good personal representative, they won't have a problem with that. Okay, because if there is some kind of mistake, okay, better to fix it without a huge court battle than going through a lot of court proceedings and still having end up having to fix it. Okay, and so this is another reason why I do these weekly updates. It's because I often talk about contemplate actions I'm contemplating. Contemplative, I guess is the word. Actions that I'm contemplating but haven't done yet, so that the people involved, if they're concerned about them, they can voice their concerns up front before I've taken the action. And then if I need to change what I'm doing, I can before I've done it, right? So you probably heard the saying, it's better to ask for forgiveness than permission. That's typically not the wise way to go in the administration of an estate or trust. Okay. And so oftentimes it's much better to get people's input first, and then take whatever action needs to be taken. Again, it's the larger, the more complicated the estate, or if there's already bad feeling between, say, creditors in the estate, or among beneficiaries or between beneficiaries, better off to socialize a potential action first rather than taking the action and then people find out about it after the fact, and now a dispute arises. Okay, so if you're a beneficiary or another party, request records, raise concerns directly. If that doesn't settle the matter, then there could be then you might want to file a formal legal remedy that could be petitioning the court for release of records. It could be petitioning the court for directions in a certain matter, and it could be even petitioning court for removal of the personal representative. Okay, if it appears that the problem is particularly egregious. Okay, so once the court is going to be petitioned, most likely you're going to want to have a lawyer involved. Okay, and they can advise you as to what the proper potential and proper legal remedies would be depending on the nature of the concern. Okay, and excuse me, once the court is involved, okay, so now there's almost for sure going to be some kind of hearing. Okay, and the judge will hear the matter. If the judge disagrees and says no, the personal representative has acted properly, that's probably going to close the matter, although the matter could be appealed. If the judge finds that there was some kind of breach by the personal representative, so he can impose penalties, he can require restitution, he can remove the personal representative, he can even initiate a criminal referral if he believes that this is a case of fraud. Okay, so all of those are potential remedies that are available to beneficiaries and other parties. I know I'm involved in a case where the original administrator was attempting to defraud a creditor. The creditor ended up having to file a claim basically in the probate court, and eventually the judge removed that administrator. Okay, and then that's why I was brought in. Okay, so these things do happen. They probably happen more often than certainly I'd like to see them happening, but indeed they do happen. Probate and Trust TV, your curated source for the most useful and insightful content on estate planning and trust and probate administration. featuring standout professionals like Bill Gross, Paul Brabelet, James Cunningham, and yours truly. Whether you're a lawyer, accountant, real estate professional, or working on your own succession plan, this channel helps you quickly find the clearest, most practical content YouTube has to offer. Subscribe now to Probate and Trust TV. Spend more time learning, less time searching. And this is Trust and Estates Weekly, and I'm your host, Kevin Bemmel. And we're talking about the duties and potential breaches that a personal representative who's administrating an estate or a trustee who's administrating a trust might become involved. And we've talked about a number of subjects. So now I want to talk about what are some defensive strategies that personal representatives or trustees can use in order to protect themselves. So it can be a sleep losing proposition to be administrating an estate, and that's not good because sleep deprivation can exacerbate a situation where you end up making a mistake or worse, breaching some duty. So first of all, anytime you agree to take such a job, whether it's as a professional or as a layperson, you need to be willing to make good faith efforts to properly administrate the estate or trust. So you have to demonstrate reasonable judgment, honest intent, lack of self interest. And if you think that you will be challenged in doing that, so then don't accept the appointment. Okay. Or if you think there's, and this is oftentimes the case, if you're representing somebody, if you're a lawyer representing somebody, right, and you think that there may be a chance of self-dealing by one heir if they're appointed, if that heir is appointed as the personal representative, so make the case to the court that you think that this person won't be able to make a good faith effort to properly administrate the estate. Okay, but for personal representatives themselves, make sure that you're demonstrating reasonable judgment, honest intent, lack of self-interest. Second, and I talked about this before, make rely on professionals. So do not make decisions when you don't have the proper expertise. Okay, so whether it's the example I gave a little bit earlier about hiring an arborist to decide whether there are protected trees on a site, whether it's a lawyer handling a legal matter, an accountant handling a tax and accounting matter, whatever it is, get the proper advice, document that advice. Okay, so it's all well and good to get the advice, but if you don't document it and follow it, you might as well not have gotten it. And because indeed, if you got the proper advice, didn't follow it, that's going to be used as evidence that in fact you intended to breach your duty, and now it's an even worse situation than it was before. Okay, so what I would say is, when in doubt, reach out to another professional and minimally discuss it with them and see if there's grounds for that professional to get further involved. I mean, I've had estates where there are, 4 or 5 attorneys involved, because although my attorney, who would typically specialize in probate administration, will always be there, depending on the assets of the estate, there may be a need for specialized legal knowledge that my attorney doesn't have. So I handled an estate where there was a need to potentially distribute some properties from an existing LLC, but there was concern about what are the property tax reassessment ramifications of doing so. My attorney could not answer that question. So I didn't have to, I suppose, but I'm not an expert in property tax assessments. So I brought in an attorney who could advise on that issue to make sure that whatever was done would not create a liability for the estate. Okay. So it's not a matter necessarily of having one lawyer or one accountant. There may need to be more than one in those categories, depending on the issues faced by the estate. Okay. And again, with appraisers, if there is real estate and a business, and there's artwork, and there's, I don't know, coin collections, whatever there is, there's horses. I talk about that on the show. Those of you who've watched it before, right? It's while the probate referee is going to value all the assets, the reality is probate referees are not reliable appraisers of assets. Most do not have true expertise to do accurate valuations of all the assets. Okay. They're appointed by the court to perform a certain function, but if the estate is large enough that an estate tax return, a 706, needs to be filed, and it's going to be reviewed by the IRS, a probate referee is not going to cut it, okay, in terms of providing valuations that will pass IRS scrutiny. And so there may be a need for multiple appraisers to make sure that the assets were valued correctly. And so to make sure that you're not accused of some kind of breach of duty, you're going to want to engage the proper appraisers, the properly qualified appraisers, I should say, depending on the type of assets held by the estate. Okay, and then, excuse me. Okay, and then next, you want to make sure you have a paper trail on various decisions, advice received, rationales for actions taken. I mentioned having a timeline on decisions before, but the timeline should be annotated with what was done, so that if need be, it can be reconstructed and presented to the court. Okay, so make sure that you have things in writing. Okay, my general rule is I do everything by email. Okay, emails are valid evidence in court, number one. Number two, when things are in writing, then you know there, you don't get into a he said, she said kind of situation. Where I do discuss things uh, verbally, I will follow up with an email confirming what was discussed. Pardon me, got a frog in my throat, doesn't want to go away. Okay, so make sure you have a detailed paper trail. And finally, if some kind of dispute does arise, so respond in a timely fashion. Okay, don't let it fester. So the longer things go unaddressed, the more likely they are to become a problem, to kind of explode, and now it'll be much more difficult to resolve them than it would have been if they had been handled quickly. So if a dispute arises, and if for whatever reason you're not working with an attorney, it's time to bring in an attorney quickly. Okay, and get that lawyer up to speed as quickly as possible. Okay, cooperate with court procedures, respond promptly to demands for information, whether it's production of documents, interrogatories, all these things in the discovery process. Comply with them unless your lawyer is advising you not to, and then your lawyer will need to take steps to either quash the request or to demonstrate to the court why the request is unreasonable, or apply to the court to justify the delay in response. Okay, so those are some defensive things that personal representatives can do in order to avoid being held liable for some alleged breach of duty. Okay, and then finally, what tools are available in order to mitigate your risk? Okay, so first of all, There is executor or personal representative liability insurance available, okay, and they will cover legal fees and judgments that result as a result of mistakes made by fiduciaries. Now, if you're a professional fiduciary, you can get what amounts to errors and omissions insurance, E&O coverage that is available. Okay, one of the best ways to get it is as a perk by joining the ITA, the Independent Trustee Alliance, because you can get it, through what amounts to a business association at a reduced rate. Okay, so if you're concerned about this, and if you're a professional, you should be, then seriously consider getting some sort of professional liability coverage, or if you're a lay personal representative, some kind of executor liability insurance. Number two, in many cases, the court will require that the personal representative be bonded. So that bond essentially insures the estate against mismanagement, or what's known as conversion, that the stealing that I mentioned before. So if a personal representative were to take money out of the estate that didn't belong to him, the bond would pay off to make up for that theft. And then the bonding, the company that issued the bond, it'll now be up to them to recover the money from the personal representative. So the estate is protected, which is why the bond is required. Okay. And then, like I said, the bonding company is left to deal with the personal representative in terms of recovering the money paid out. Okay, and then finally, and I mentioned this before, if you are uncertain about whether you should do something or not do something, apply to the court for for instructions, basically, and these go by different names depending on the particular jurisdiction. But you know as a personal representative, you can file for an instruction from the court. You can file a petition with the court. So let's say you have the authority to sell a property, but as a result of certain issues, you're not certain that you should go through with the sale. So even though you're not required to get court confirmation of that sale, you can still apply for court confirmation. Okay, and in that case, the court will issue a decision one way or the other. And once the court has made the decision, the heirs or whoever else might be concerned about the sale of the property can't come back and say, well, you shouldn't have done this, because your response will be, well, the court said I should, so I did, or the court said I shouldn't, and so I didn't. Right? That's the benefit of applying to the court for direction, because it's in essence sort of like litigating the issue in advance, except that it's not really it won't turn out to be a long and egregious litigation in the way that litigation after the fact oftentimes is. Okay, and also then the judge will recognize, look, you're, as the personal representative, you're looking to do the right thing. And so the judge will, if allegations are made of breach of duty, the judge will see, wait a minute, that can't be the case, because the personal representative is by the submitting to or requesting instruction or submitting a petition or whatever, is looking to make sure that he takes the proper steps, does the right thing. Okay, so those are the risk mitigation tools. So the bottom line is, when you're a personal representative, you have to know and fulfill your fiduciary duty. You have to be careful in doing so. And there are steps that beneficiaries and other interested parties can take if they think you fail to do so. And there are things you can do to protect yourself. Okay, so take this to heart, and if you're not clear on some of these things, I'd encourage you to watch this or listen to this show again, and make sure you understand these are the fundamental principles. Okay, obviously we could get into lots and lots of examples that that are illustrative of the kind of problems that arise. I know I've certainly dealt with them in my career. Hopefully, I've dealt with them well, and in the end, gotten to a satisfactory result. But the liabilities that a personal representative assumes are real, and therefore how the personal representative acts is very, very important. So that's the show for today. Tomorrow, Tuesday at 10 a.m. is my show, Business Lessons from the Military. My guest is Darren Burrell, a United States Air Force veteran who became a venture capitalist, and he's going to talk about that journey and the lessons he learned from the military that have allowed him to be a successful venture capitalist. On Wednesday at 10 a.m. Pacific time, my guest is John Soleter, and John is he's a businessman of my vintage, I'll say, has an entrepreneur many times over, and he's going to talk about how do you be successful in business. He's going to talk about what he's learned over a lifetime of starting and running and selling businesses. So please join me for my conversation with John. And then 1 week from today, then will be the next edition of Trust and Estates Weekly. So I thank you very much for joining me. Wish you a wonderful rest of the day. And signing off as I always do, Marie, darling, you are my belle.